The government announced the end of no-fault evictions in the UK as though the problem of landlords removing tenants without genuine cause was about to be solved. It isn't, because while Section 21 is being phased out, the legal framework that replaces it contains specific grounds for possession that in practice function as workable alternatives for landlords who want a tenant out and are willing to go through the correct procedural steps to achieve it. 7 of those grounds in particular are being used, and in some cases actively misused, in ways that most tenants have no idea are happening until the notice is already on the doorstep. In the next few minutes, I'm going to walk you through the 7 legal routes landlords are using to evict tenants even after no-fault eviction is supposed to have ended. Which of them are straightforward and legitimate, which are being stretched beyond their intended purpose, and what tenants actually need to know to protect themselves. I've been tracking the property market for years, and the gap between what tenancy reform was supposed to deliver for renters and what it is actually delivered in practice is one of the clearest examples of a well-intentioned policy being navigated around by people with the incentive and the legal knowledge to do so. Let's get into it. Before going through the 7 routes, it's worth being clear about the context. Section 21 allowed a landlord to serve notice on a tenant and recover possession without giving any reason at all, provided the correct paperwork was in place and the notice period had been served. Its replacement under the renters' reform agenda relies on a set of specific named grounds under Section 8, meaning the landlord must now have and state a defined reason for wanting the property back. What the reform was supposed to prevent was arbitrary, retaliatory, or convenience-driven eviction. What it has actually created is a landscape where tenants need to understand not just whether their landlord has served notice, but which specific ground is being cited, whether the landlord actually meets the legal test for that ground, and whether the procedural requirements have been correctly followed, because the answer to all 3 of those questions determines whether a notice has any legal force at all. Route number 1, rent arrears under Ground 8. This is the most commonly used mandatory ground for possession, meaning that if the landlord can demonstrate the tenant meets the threshold for arrears at both the point the notice is served and at the point the case is heard in court, the court has no discretion, it must grant possession. The threshold requires a significant level of arrears to be outstanding, and the fact that the ground is mandatory rather than discretionary is why some landlords who want a tenant out for entirely separate reasons have been known to manufacture or provoke a rent arrears situation, whether by refusing to provide updated bank details for payment, by rejecting payments on technicalities, or by applying charges the tenant disputes that push the arrears figure to the required threshold. Tenants who receive a Ground 8 notice should check not just whether they owe rent in principle, but whether every payment was correctly directed, every rejection of payment was legally valid, and whether any disputed charges have been properly applied under the tenancy agreement. A tenant who has been paying rent consistently but has been paying it to an account the landlord later claims is no longer valid without adequate notice of the change may find a Ground 8 notice being served on the basis of arrears that have in practice been engineered rather than genuinely accrued. Route number 2, the landlord or family member moving in under Ground 1. This ground allows a landlord to seek possession on the basis that they or a named close family member intends to occupy the property as their principal home. Used genuinely, this is a reasonable and legitimate ground. Used as a mechanism to remove a tenant the landlord simply no longer wants and then not actually moving into the property or moving a family member in only briefly before reletting, it crosses into misuse that is technically fraudulent, though notoriously difficult for a former tenant to successfully prove and pursue. The intended protections in the reformed framework include a restriction on reletting the property within a defined period after recovering possession on this ground, which provides some deterrent, but enforcement relies on the former tenant becoming aware of the reletting and taking action, which the majority of evicted tenants are not in a position to monitor or pursue. Route number 3, the property being sold under Ground 1A. This is the equivalent ground applying to landlords who claim they intend to sell the property. A landlord who genuinely is selling, moving through conveyancing and completing a sale, is using this ground as it was intended. A landlord who lists the property, recovers possession, accepts an offer that later falls through and then relists not for sale but for rent, or who uses the ground as a temporary exit mechanism from a difficult tenancy with no genuine long-term intention to sell, is using a legitimate legal mechanism in a way that stretches considerably beyond its intended purpose. As with Ground 1, the deterrent relies on the former tenant monitoring what happens to the property afterward, and enforcement requires the former tenant to actively bring a case, which in practice most tenants, displaced and focused on rehousing, never do. Route number 4, persistent arrears under Ground 11.
Unlike Ground 8, which requires a specific level of arrears to be outstanding, Ground 11 can be invoked where a tenant has persistently been late paying rent, even if no arrears are currently outstanding at the time the notice is served. This is a discretionary rather than mandatory ground, meaning the court can consider the specific circumstances before deciding whether to grant possession. In practice, it gives landlords a possession route against tenants who pay rent but consistently pay it late, and the definition of persistent is determined by the court on the facts of the case. Tenants who have a pattern of late payments, even small and quickly resolved ones, should be aware that this pattern can be cited as a ground for possession even when they believe their situation is essentially fine because no arrears are currently owing. Route number 5, deterioration of the property under Ground 13. A landlord can seek possession where the property or any furniture provided has deteriorated due to waste, neglect, or default by the tenant. This is another discretionary ground, and it requires the landlord to demonstrate actual deterioration beyond normal wear and tear. Where a tenancy has become adversarial and the landlord is looking for a reason to recover possession, the property's condition, particularly in relation to professionally prepared inventories and check-in reports, can be used to build a case under this ground. Tenants should ensure they maintain clear contemporaneous records of the property's condition throughout a tenancy, not just at the beginning and end, specifically as protection against normal wear and tear being recharacterized as neglect or damage. Route number 6, nuisance or antisocial behaviour under Ground 14. This ground covers situations where a tenant has been guilty of conduct causing nuisance or annoyance to neighbours or others in the vicinity, and it can in some cases be applied on a discretionary basis even where the conduct complained of is relatively minor or disputed. In adversarial landlord-tenant relationships, a landlord who can produce evidence of complaints, whether from neighbours, a managing agent, or local authority records, has a potential possession route even where the underlying incidents are contested. Tenants facing this ground should engage promptly and in writing with any complaint raised, documenting their own account of events clearly, because the evidence assembled during the tenancy itself is what will matter if the case reaches a tribunal.
Route number 7, breach of tenancy agreement under Ground 12. A landlord can seek possession on the basis that the tenant has broken a term of their tenancy agreement other than the obligation to pay rent. This is a broad and flexible discretionary ground, and its scope depends entirely on what the tenancy agreement actually says. Common breaches cited under this ground include keeping a pet where the agreement prohibits it, subletting without permission, running a business from the property without consent, or making alterations without approval. Where a tenancy agreement is broad in its restrictions and a tenant has lived in the property for years, there may be inadvertent breaches of specific clauses that both parties had effectively ignored until the landlord needed a ground for possession. Tenants should read their tenancy agreement carefully and be aware of which clauses are actively enforced and which have been tacitly permitted over time, because a landlord who suddenly decides to enforce a clause that was previously ignored may be using that breach as a procedural vehicle for possession rather than genuinely responding to a change in conduct. Now here's what connects all 7 of these routes, and it's the part that tenancy reform advocates are increasingly vocal about. The replacement of Section 21 with a reformed Section 8 framework hasn't eliminated the ability of a landlord who is determined to remove a tenant to find a legal mechanism to do so. What it has done is shift the terrain from a simple, low procedural cost process into a more complex, evidence-dependent one where the landlord now needs either a genuine statutory ground or the patience and resources to build a case on a ground that can be challenged. That shift has real value for tenants who actively engage with the process, understand the grounds being cited, and dispute procedural errors or factual inaccuracies. It has considerably less value for tenants who don't understand the framework well enough to know that the notice served on them has a specific legal basis that can and should be examined. Here's what nobody puts together properly. The tenants most vulnerable to these 7 routes are disproportionately those who are least equipped to engage with them. Renters on lower incomes, renters without access to legal advice, and renters who assume, incorrectly, that a landlord serving a formal notice means possession is legally inevitable. A Section 8 notice is not an automatic order to leave. It is the beginning of a legal process that requires the landlord to go to court and satisfy a judge that the ground cited is properly established.
In that population of renters who don't know this, the practical gap between the reform's stated intent and its actual effect on the ground is much larger than the policy change's public reception suggests, not because the reform is dishonest, but because the protection it offers is only as effective as the tenant's ability to access and exercise it.
Here's how this plays out for tenants who don't know their rights. They receive a Section 8 notice citing one of these 7 grounds, they don't recognize the ground being cited, they don't check whether the procedural requirements were correctly followed, and they vacate the property before any court hearing takes place, meaning the landlord never has to demonstrate to a court that the ground was properly established in the first place. The landlord's procedural success in this scenario has nothing to do with whether the ground was genuine, it has everything to do with whether the tenant knew they didn't have to leave until a court actually ordered it. Here's how this plays out for tenants who do understand the process. They read the notice carefully, identify the specific ground being cited, and check whether the landlord has correctly followed the required notice period and documentation requirements for that ground. Where the ground is discretionary rather than mandatory, they understand that the court will consider circumstances before ordering possession, and they prepare evidence relevant to those circumstances. Where the ground involves an alleged breach, they gather contemporaneous documentation of their own version of events, and where the ground appears to have been incorrectly served, improperly cited, or based on a factual claim they dispute, they seek advice from a housing solicitor or a specialist charity, because challenging a notice at the earliest opportunity is almost always the most effective approach.
Here's how this plays out at the wider level. Expect the use of Section 8 grounds to continue rising as Section 21 is fully phased out, with Ground 1 and Ground 1A in particular likely to attract increasing scrutiny as campaign groups and housing charities track how often landlords who cite intention to sell or move in are actually doing so, versus reletting the same property shortly after recovering possession. Expect further reform proposals to emerge targeting the enforcement gap, the practical difficulty former tenants face in pursuing a landlord who misused these grounds, but expect those proposals to move slowly through a legislative process that has already taken considerably longer than originally projected, and expect the pattern of tenants vacating before court hearings simply because they don't understand the process to remain one of the least visible but most consequential failures of the current framework's ability to deliver the protection it was designed to provide. If you're a tenant who has received any notice from a landlord, the single most important thing to understand is that you do not have to leave until a court orders it. A Section 8 notice is the beginning of a process, not the end of one. Free advice is available through shelter, citizens' advice, and housing duty solicitor services at court, and for many tenants facing proceedings, that advice is the difference between leaving a home they have a legal right to remain in and successfully challenging a notice that was improperly served or factually contested. Tenancy reform changed the rules. It didn't change the underlying dynamic of a rental market where landlords frequently have more legal knowledge, more professional representation, and more resources than the tenants they're dealing with. Understanding which 7 routes exist, how each one works, and what it actually takes to challenge them is the practical foundation of whatever protection the reformed framework is actually supposed to deliver to the people it was designed to protect.